The courtroom is packed full for these very important proceedings. It's the adoption of the final written addresses of all parties in the petitions filed by the Labour Party's governorship candidate Rhodes Vivour and that of the PDP Olajide Adediran, popularly known as Jandor. Based on the agreement of parties, the three-man tribunal first listened to the adoption of final written addresses of parties in the petition filed by Rhodes Vivour. The petitioner had called a total of 10 witnesses in proof of his petition, and counsel to INEC, Senior Advocate of Nigeria Charles Edosonwo, in adopting his final written address, noted that the witnesses woefully failed to establish that the polls were not conducted in substantial non-compliance with the Electoral Act. He asked the tribunal to dismiss Rhodes Vivour's petition for lack of evidence.
INEC responses in any of these cases or petitions is to come to court to defend the work they did in the election. Don't forget, INEC is a public body that is entrusted with a public duty, expending the public's money. It is therefore accountable to come in these proper cases, come and explain the job they did. And in this case, we were able to, I believe, we were able to show the court that INEC's conduct in this exercise that is being reviewed now by the court tribunal was in substantial compliance with law. In this case, the Constitution and the Electoral Act, rather.
Counsel to the second and third respondents, Senior Advocate of Nigeria Chief Wole Olanipekun, and counsel to the APC, Senior Advocate of Nigeria Abiodun Owonikoko, in the adoption of their final written addresses, told the tribunal that the petitioner abandoned his petition in his final arguments. There was no reference to the second respondent, Governor Babajide Sanwo-Olu, but instead the address dwelt on the third respondent and the issue of his dual citizenship. Counsel to the petitioner Olagbade Benson countered these arguments and urged the tribunal to uphold the petition.
The Deputy Governor of the APC, Dr. Obafemi Hamzat, has admitted in his Form EC9 that he made a declaration of allegiance to the United States of America. He even took the same document before a commissioner of oaths and swore to an affidavit saying that, yes, it is true, he made a declaration of allegiance to the United States of America. What's more, in Section 182(1)A says that once you have made a declaration of allegiance to another country, you are disqualified. It borders not on his citizenship. They continue to think we're talking about citizenship. Our case is not about citizenship.
America developed today by opening up to other nationals. But they also have that understanding that if you don't give people the opportunity to retain their nationality of birth, it will be difficult to attract them to America. That's the advantage of having dual nationality in Nigeria. But we are misunderstanding and trying to now demonize the objective. It will be dangerous for us if Nigerians who are remitting money from all over the world to Nigeria, sustaining our economy in terms of forex inflow, are made to believe that because they have other nationality, their right as Nigerian citizens by birth is, as a disadvantage. So we are thinking that this petition gives the tribunal an opportunity to clarify that. It's part of the things that people who have been talking about diaspora voting. What is the purpose of that? If, because you are in Nigeria, in America, you are asking for diaspora, but you cannot contest for offices. So we think these are part of the issues that the tribunal hopefully will resolve.
The tribunal also took arguments when parties adopted their final written addresses in the petition filed by the PDP and its governorship candidate, Jandor.
Our petition, as you heard, was premised on 2 grounds of disqualification against the governor, and the candidate was declared second by INEC after the elections. Now, what we've done through our evidence and avalanche of documents we've tendered was to demonstrate before the court that these 2 candidates violated provisions of the Constitution in their candidacy. We've shown before the court, for instance, that you cannot be a candidate for an election if you are not qualified, if you are not properly sponsored by the political party. We've also been able to show before the court that if you submit any false certificate to INEC, then you'll be disqualified. And we've been able to show before the court, for instance, that Exhibit P36, which is the GCO level certificate tendered by His Excellency, submitted by His Excellency to INEC, was false.
All the arguments are in, and the tribunal has adjourned to consider its verdict. It will communicate the date of judgment to parties when it is ready. The expectation, however, is that the judgment will be ready on or before early October, in line with the constitutional provision, which gives 180 days for the completion of these exercises. Shola Shoyele, Channels Television News.